Hello, everyone. I'm Matt Kreider, insurance advisor at Pet Shower Insurance. Welcome to our podcast series where we uncover the cyber threats facing small to mid-sized organizations and how they can protect themselves in today's ever-connected and digital world. Today, I have the pleasure of introducing Jon Dartley. Jon is an attorney with over 20 years of experience representing a variety of organizations, including nonprofits and technology startups, to name a few. He has extensive knowledge in matters related to privacy, big data, and technology, which is why I asked him to join us today. He also serves as of counsel at Perlman & Perlman, a premier law firm for serving nonprofits. And he also runs his own practice to serve the for-profits called Dartley Law PC. Jon, welcome to the podcast.
Thanks, Matt. Thanks for having me.
Sure. Just to get started, how real, from your perspective, are the cyber threats to small to mid-sized organizations, and what methods of cyber attacks should these firms be most concerned about?
Yeah, very real, unfortunately. And the studies show year after year that the amount of breaches, the amount of people affected each year grows. 2024, again, showed an increase over 2023. Not only that, but the cost of those breaches, of attending to the losses that they can cause, also rise every year. And honestly, small to mid-sized organizations are at a higher risk, I would say, than a lot of larger organizations, as they often are targeted specifically because hackers understand they do not have the same level of defenses. They don't have a lot of the same organizational background in terms of dealing with the defenses that large organizations might have to employ. So they tend to be actually talk about like low fruit for the picking, that I think there's a higher proportion of small to mid-sized organizations affected compared to like larger organizations.
Listen, that makes a lot of sense.
I would also add that particularly I tell nonprofits that studies have shown that nonprofits are actually more affected by a data breach than their kind of for-profit brethren, because nonprofits actually have, I guess you would say, more fungible, meaning when, if a Meta, Facebook is hacked, or if your insurance company is hacked, people don't tend to just choose other insurance companies. It's not that easy to do, right? There aren't that many alternatives to some of these big social media players that people are ensconced using. But nonprofits, if a small and mid-sized nonprofit has a data breach, studies have shown that people next year or the next time they donate, they may just simply choose another organization that does similar work, but they feel might have better things in place to protect the data. So I think it's even more important for small and mid-sized organizations from a reputational standpoint to be more focused on how to protect themselves from these types of hacks.
From your perspective, what are some of the legal and regulatory implications that's involved in a cyber attack?
Yeah, so as right now, there's no kind of national federal legislation governing data privacy and cybersecurity that applies to both for-profits and nonprofits. So it's a bit of a patchwork. There are a number of state laws in place from California, Virginia, and Colorado. If you look at the landscape the next year or two, there are a number of other states that will soon be instituting data privacy laws. It makes it a little bit harder for nonprofits and any kind of organization to comply because it's very state specific. The good news is that a lot of these state laws do exempt most tax exempt organizations with there are some caveats to that, but generally speaking, like the Californias and the Virginias and the Delawares don't apply to nonprofits, but there are some that specifically do include nonprofits. One would be Colorado. Another one is New York State. I always say know the laws, know what you do, know the kind of data you collect, and then know what state laws and what other kind of laws might apply to the work you're doing and the data you're collecting.
So if you're an organization, whether nonprofit or for-profit, and you have operations or employees in other states, you really need to be thinking about what those state regulations are in each state that you operate.
Yeah, good question. You don't have to have employees. So for all these regulations, it's not tied to the employees, it's tied to the data you collect. And there are some base levels. So in Colorado, and a lot of the states have, it's either 100,000, you have information on 100,000 residents, or you derive more than 25 million in funds, it could be donations, or a certain percentage. So it's usually, so a lot of nonprofits, even though they may have Colorado residents, they may not have 100,000. A lot of small, mid-sized won't. But these things are always changing. It's a changing landscape. And I'll give you one example, something that most organizations have never heard of, the New York SHIELD Act. It has been in place for a number of years now. It applies to for-profits and nonprofits. It literally has no threshold. So it applies to all organizations if they're collecting certain types of sensitive or personal data. We can differentiate between the two different types of state regulations. Most of them these days are about giving more rights to donors or to constituents. So you have the right to know what kind of data an organization is collecting about you. You have the right to change that information. You have the right to have them delete the information. And that's what many states have. New York is a little different. New York is focused on trying to minimize the risk of a hack happening, a data breach happening, and then also mitigating the effect of the data breach by requiring organizations to have certain policies and procedures in place. So New York Shield, as opposed to a lot of the other state regulations, require certain provisions with vendors to make sure they're taking certain security requirements to protect the data they collect on your behalf. And then there's some other like data incident response plan to make sure if a breach happens, you know what to do and who to call. It's a little different than a lot of the other states, but it does apply to nonprofits. And honestly, even if the nonprofit wasn't collecting the type of data that New York Shield governs, it's really just best practices. And I always tell my nonprofit clients, you should strive to meet those obligations, because at the end of the day, even if they don't apply to you, they are going to put you in a better position to both minimize the risk of a data breach and mitigate the effects if a data breach happens.
Gotcha. So if you're, let's say, a Colorado-based organization and you're collecting information from citizens in New York, you need to pay attention to the SHIELD Act.
Yeah, all these acts, only applies to not where you're based. It applies to the data you're collecting on the state residence. So again, nothing to do with domicile.
Don't most states have some kind of, for compliance reasons, some kind of response requirement if data is exposed in the event of a cyber attack?
Yeah, good question. Yes, I think 48 states have on record data breach notification requirements that have to be met. But in many cases, it depends on the type of data that is accessed. And the good news is often a lot of the data that nonprofits have is not considered personally identifiable information, PII. And the reason being, it's just a name and an email address, or a name, even a home address. That's more or less public information. Typically, what triggers notification under most states has to be that type of information, along with banking account information, credit card information, social security, any kind of financial information. And so one thing that often nonprofits do collect, and I tell them they shouldn't, is date of birth. So a name, an address, or an email address with a full date of birth. And some states now triggers notification.
Gotcha. What should an organization do to minimize the impact of a cyber attack and data breach?
Yeah, so a number of things. First, I say if an organization has not done it, doing what I say a data privacy assessment. It's stepping back and taking a big picture look at the organization, the types of data they collect. I always say if you remember from the newspaper days, that when you're interviewing somebody, the 4 W's and the H: why, where, when, who, and how. So I often recommend that this is boiling it down to the basic premise, but a data audit is usually more involved. But you should be able to answer these types of questions. What kind of data do I collect? Many organizations collect more data than they need and keep it longer than they need to. So for an example, I mentioned date of birth. It's fine to have a month and year, but when you have a full date of birth, the day, month, and year, that's where you can trigger, if there's a breach, these state obligations. And when I ask a lot of organizations I deal with, I say, why do you need a specific day? Often it's not any really specific or particular reason. Maybe they want to wish somebody a happy birthday. They can still do that. We know it's your birthday month. So the point is, make sure there's a reason for all the types of personal data you're collecting. So that's the kind of what. Then it's where's the data housed? Is it offline? Is it online? Who are the vendors? Just get a handle on that. And then who has access to it? Volunteers, employees. When employees leave, how quickly are they cut off from the system? Do vendors have access to PII? Do they need it? How is the information protected? That's very important. You want to know both like the physical, administrative, and technical safeguards in place to protect the data. So physical means, hey, if you have some hard files, are the files locked? And you want to know the technical measures, what kind of things you're employing to protect the data. Administrative as well, what are the protocols in place for employees? And do you have privacy instructions in place that employees have to sign on to? So all those things are really important. That the last one is, when is the data deleted? Most organizations, as I mentioned, collect way more data than they need, and they tend to keep it much longer than they have to. And the more data you have and the longer you keep it, if there is a breach, it just means you're subject to more penalties, more notifications. So I always advise organizations to periodically look at the data you have. If you no longer need it, get rid of it.
You mentioned vendors. So if you have a third party that you're hiring that may house information, or other some kind of service provider that has access to that information. How do you protect yourself as an organization for an act or omission or error that a third party provides? What can you do as an organization if they make a mistake on their end? How can they protect themselves?
Yeah, so good question. Let's break it into two types of, I would say, vendors that nonprofit, small to mid-sized organizations typically work with. One is, let's just say, consultants that come in. They could be fundraising consultants, they could be other types of consultants. They may get access to your donor data, they run reports, give analysis, give help with strategy. So those are usually through a professional services agreement, and you need to make sure that agreement has certain precautions in place. If it's a big enough provider, you might want them to have insurance to cover if they do something wrong, because often when data is leaked, it's often through a third party. You want to make sure you have an agreement, certain obligations that they'll take to protect the data. Then the next one, which I think is the bigger issue for most organizations in general, are the third-party vendors. These days, it used to be 10 to 15 years ago, people would have servers in their office and everything would be done with internal team. And these days, everyone's outsourcing to these third-party vendors, which I think is a good thing, because a lot of these larger vendors will have in place much more sophisticated security requirements, cyber requirements. You access it, we've all heard the term SaaS, software as a service. So those vendor agreements tend to be very one-sided. I have a lot of clients that come to me and say, oh, we got this vendor agreement. They said we can't make any changes. That's almost never the case. You can always make changes to an agreement, and you should. And New York Shield, as we mentioned before, actually requires that you do. And actually, a lot of the other state regulations are requiring now organizations get more proactive in negotiating these. But A, you should never just take a vendor agreement and sign it. It should always be reviewed by a lawyer who knows technology agreements. Any vendor agreement, any third party that's getting access or housing an organization's data, A, there should be certain promises in terms of how they can protect that data. That's written into the agreement. Should there be data breach, that they're going to cover the organization for regulatory notification, credit monitoring, whatever it is. There should be definitely a breach notification section that within 48 hours, they'll notify the organization that there's been a data breach or reasonably suspect that there's been a data breach. There have been a lot of organizations in the past, vendors, I won't mention names, but one very large nonprofit services vendor that had a breach and didn't let clients know until 7 months later, which got a lot of press a couple of years ago. So having that requirement in an agreement, and then also requiring the vendors that if there's a data breach, again, that they cover your costs. I've never actually had a vendor say no to that. It's a reasonable request. They may try to put some limits in it, but it's something you should always ask for. Limitation of liability. Most vendor agreements, the standard form is you're limited to 6 months of fees. That's it, no matter what happens. You need to carve out certain things, and certainly a data breach needs to be carved out from the limitation of liability. If not unlimited, then it needs to be what we call a super cap, some multiple of whatever X is going to be. A couple more insurance requirements. You need to make sure that any mainstream reasonably large size or even mid-size vendor should have a robust insurance policies, including a cyber policy. You want to make sure those are listed in the agreement. You want to make sure the organization is actually named as an additional insured and indemnified for anything that happens. So it just makes it easier if there's a claim to try to get that money from the insurance company. All really important things. The last thing I would throw in there is having a term about transition. Sometimes vendors just don't work out. Sometimes vendors aren't doing the right thing on the back end. So I always build in both a termination for convenience after a certain term, and then requiring the organization to give you transition services. Often the hardest part for a small to mid-sized organization transitioning to another vendor is getting the data from one place to another. And a lot of vendors say they just won't help in order to keep the organizations with them. So having that provision in also gives the organization more flexibility to move when they need to.
What do you see is necessary on a cyber policy? What should a organization look for in their own cyber policy?
I'll tell you, and then I'll give you an anecdote. Organizations should not rely just the fact that the vendor has their own insurance, right? Any organization that collects any types of data should have their own policies in place, including a cyber policy. I have some of my clients tell me, we have a professional services policy, or we have a general policy. And as most of those policies, professional can, but most of those policies do not actually address data.
Most of the professional liability policies we see actually exclude that.
Yeah. So I say a well-rounded cyber insurance policy should include both first-party and third-party coverage, addressing breach response, addressing business interruption, data restoration, cyber extortion, legal and regulatory costs, reputational harm, and a variety of other things. And when I say first and third, First is the harm that an organization can have. And then the third party, it would be other people who might now sue the organization because the things that have happened because of the data loss. So it's important to have both coverage. It's important to read the policy. A number of years ago, I had a very large client spending close to six figures on a cyber policy with other policies. And I actually read the cyber policy and it didn't actually apply to them. It was as if they were a service provider, which they weren't. They were a very large nonprofit who worked with third-party vendors, and they were not covered for that.
Wow. Sounds like to me they were totally misclassified.
Yep,
they weren't even
exactly.
insuring the operations of the nonprofit. They were insuring something totally different. I mirror everything you mentioned. I couldn't have said it better myself in terms of reading those policies, making sure you understand it, or having someone that is a specialist that actually understands them. You mentioned other things that organizations should be doing.
Yeah, I'll give a few things. One, every organization should have an instant response plan. It's basically if a disaster happens, what do you do? And New York Shield requires this. And the whole point is, there's a saying, if you don't know where you're going, all roads take you there. If you don't have a plan in place and you're figuring out on the fly, odds are you're not going to do things as good as you would if you had a plan in place. So every organization should have, if this happens, who do we call? Your insurance carrier should be somebody you call immediately. Your lawyer should be somebody, PR agency, what executives are involved. So definitely having an incident response plan that kind of maps out what you do when something bad happens has been shown to help immensely in terms of mitigating damages that can flow from a data breach. Another thing that's really important to have is a data retention and deletion policy. I mentioned before that organizations tend to collect way too much data and keep it way too long. Data retention and deletion policy is a policy that across the organization tells people what types of data you're collecting, how long to keep it, how to get rid of it when you no longer need it. Very important to have. Many organizations don't, but it's like the guidebook to how to be good stewards of the data you collect. Another one, this is an easy kind of low-hanging fruit, is privacy policy on the website. Organizations tend to maybe have a policy that they took from somewhere else. Don't do that. The most important thing about a privacy policy, and I tell all my clients this, you can do almost anything you want with the data you collect, as long as you're transparent about what you're doing with it. Do as you say and say as you do. Even if an organization wrote a privacy policy and posted on the website 8 years ago, odds are a lot of things have changed in terms of the type of data they collect, where they get it from, how they share it. So again, having a kind of well-crafted, bespoke privacy policy that accurately reflects the types of data an organization collects and what they do with it is really important from a variety of perspectives. But should anything ever happen and your privacy policy didn't disclose you were doing those types of things with the data, that can be a big issue as well.
And keep it up to date.
Yeah. So for example, the Colorado law applies to your particular nonprofit. You actually have to make certain disclosures that Colorado requires. You need to keep up and probably every year look at the legal landscape, look at the data you're collecting, and see whether the policy needs to be amended to reflect that work.
And looking at today and tomorrow, what sort of rising trends are you seeing, whether it's cybersecurity or just technology, from a legal perspective that organizations should be aware of?
Yeah, things are just getting more complex, and data privacy is not going away. Your donors care about it more and more. States care about it more and more. At some point, the federal government will probably care about it as well, and we'll have maybe federal legislation, which might make some things easier. But the most important thing is being proactive. The difference I see between for-profit and nonprofits is for-profits often take privacy as what you call a C-suite concern. Often there's a chief privacy officer, there's someone in charge, they report to the CEO, and it's just something that across the organization, they're thinking about it. Nonprofits tend to be, I think, a little bit behind in terms of where the for-profits are and taking privacy and cybersecurity as a serious kind of top concern. Most organizations, I say, should have somebody in charge of cyber and privacy. New York Shield actually, by the way, requires it. I didn't mention that, but requires if you're collecting certain amounts of data, you need to have somebody that's appointed to be the chief privacy officer. For many of the clients, it's me. It doesn't have to be an internal person. I would also recommend anybody. There are a lot of technology lawyers out there similar to me. I came from both the technology world. For a number of years, I was at Blackbaud as their assistant general counsel for a number of years. So I came from the vendor side, and I have a lot of work in working with nonprofits and working in technology and understanding technology. I've owned a couple of technology companies, but working with a lawyer, when you're talking about technology, cybersecurity, privacy, it's important to work with somebody who knows that landscape. There are a lot of kind of general practitioners, and what a lot of clients do is sometimes, we have a lawyer, so he just looks at everything. But again, It's for these types of things, you need to have kind of subject matter expertise. And I mentioned before, in terms of looking at vendor agreements, it's not what's in the agreement, it's what's not in the agreement that you should know to put in. So it's not just like looking at the four corners of a contract and say, oh, instead of 30 days, let's change it to 15 days. It's more about all the other provisions that should be in that contract, a technology contract or a contract that's related to data collection that kind of needs to be inserted and to really protect the organization from any future harm.
Sure. And with the increasing use of AI, how is AI changing that?
It's important for now nonprofits or any organization to have an AI policy to take how AI is being used, what types of services you use it for, how is it being screened. And so I'll give you a couple examples. Yes, AI, there are a lot of free versions out there. In order to use, for nonprofits who want to use it for their work, they need to have a commercial license. If you use it without a commercial license, or if you use it for a free license, a lot of the data you collect is used by AI for their machine learning, which means the data you're giving them, they're now using. So that could be in violation of your privacy policy. It's probably not a best practice. Most organizations I know, when they're working with an AI provider, want to have a commercial license that allows them to use the AI, leverage the platform, but does not allow the AI to use the data they input into it for machine learning and to share with in their database and their algorithm. So that's really important. Practical piece is if you're using AI, if people using it, the home version without a commercial license, is probably copyright infringement. There's a lot of that's these companies are in business to make money. Any organization using AI should have an AI policy, should tell people which ones are approved to use. They should have there's commercial license with at least one major provider, and then really let people know what kind of data should be inputted and how it should be protected.
With the commercial license, the AI technology you're saying, are they essentially putting a fence around any data that you input into the AI, and they're just still pulling information from the outside in to benefit the organization? Is that kind of what a commercial license does?
Yeah, exactly. So if I go on Perplexity now, with just my kind of free, 3 times a day, I can ask a question. Anything I ask, anything I put in there, they can take. They can use it. Yeah. If I had a commercial license, they wouldn't be able to do that. So nonprofits are using it sometimes to write a blog or do a PR piece. That's fine. But if you use it without an unpaid license to create a blog and you post it, that's technically could be copyright infringement.
Meaning if they take someone else's information that the AI has access to?
Yeah. So it's wise for any use in a nonprofit, make sure you vetted, there are a lot of them out there, you vetted which ones are approved vendors to work with the organization. You have rules around the do's and don'ts. So for example, like if you're using it to create a blog or a PR piece, check the facts, make sure sometimes AI has hallucinations. They say things that aren't true. Sometimes they could take something with verbatim from somewhere else. That could be copyright infringement. So you need to do a little due diligence. Those things should be built into an organization's AI policy.
Gotcha. I see you got a lot of bottles of wine back there. Is there any bottles you recommend if you've had a cyber attack and need to take the edge off?
Yeah, I have some very nice Italian Brunellos that would hit the spot.
Nice. Listen, if you ever need some help, let me know. Listen, it was a pleasure, Jon. I always learn something new when I speak to you, and I really appreciate your time. Thanks for coming on.